Good day, everyone. I am Diane Rose Salomon Torn. Today, I will give the conclusion of our topic, Enforcing Corporate Social Responsibility Codes on Global Setting, which is the scopes and limits of enforcing the corporate social responsibility codes. The key issue in the debate on corporate social responsibility is to what degree CSR codes can be implemented between private parties. Applying a doctrinal review of CSR codes allows for the possibility of private law compliance. In example, enforcement by contract or tort. Subsequently, it is argued that the social expectations have not yet reached a point where the average customer who buys a product from a retailer will legitimately hold the retailer responsible for breaches of the norms embedded in the code. Typically, CSR policies include a pledge by companies articulated in their declarations of business values or corporate conduct codes of conduct, rather, to greater concern for the environment, rights, fairness to suppliers and consumers, and opposition to bribery and corruption. However, the spectrum of issues is continually expanding from the promotion of diversity at work, ethical practices, responsible marketing, and responsible approach in the food industry to the topic of obesity in particular. What is corporate social responsibility codes? Corporate social responsibility codes are guidelines that business establish and publish on a voluntary basis with the goal of demonstrating to the public their commitment to uphold human rights, to strengthen basic labor conditions worldwide, and to protect the natural environment. This is according to Anna Becker's Enforcing Corporate Social Responsibility Codes in 2015. The scopes and limits of enforcing the CSR codes can be addressed in the following. Contract law. Contract law is a body of law that regulates, enforces, and interprets agreements relating to the exchange of goods, services, assets, or money. Pursuant to contract law, an arrangement between two or more parties or business organizations in which there is a commitment to do something in exchange for benefit or advantage is legally binding. Contract law is at the core of many business transactions, and anybody entering into a contract should have the risk that failure to comply with the contract, even by accident, could lead to serious problems. Next is the corporate liability. Corporate Corporate liability is generally the legal responsibility for illegal acts of an organization, in example, a business or a company. It is most widely used to identify acts that may be considered unethical by the organization itself or its workers. In certain situations, it may also refer to a lack of action when the action was required for the business to comply with the law. Government authorities, shareholders, and the other third parties are now carefully scrutinizing corporate actions and seeking responsibility for misconduct. This increased focus has contributed to the tightening of regulations aimed at deterring and punishing corporate corruption and proactive government regulation. The corporate code generally imposes liabilities on the directors, trustees, or officers who willfully and knowingly vote for an for or assent to patently unlawful acts of the corporation or who are guilty of gross negligence or bad faith in directing the affairs of the corporation. This is according to the Corporate Liability of the Philippines. Corporate responsibility for the conduct of crimes is usually not enforced by Philippine law. Rather, it is the directors, officers, or staff of the company who are held responsible for the crimes and are therefore persecuted and disciplined for the same. However, if the criminal statute establishes a crime for which a corporation can be convicted and then imposes a fine or even a fine and imprisonment, as a punishment, the corporation may be charged and if found guilty may be fined. In the other hand, where the law describes a crime that may be committed by a company but provides that the punishment shall be levied on the officers, directors, or employees of such corporation or individual liability for offense, only such persons shall be persecuted. The primary registration or business license of a Philippine company or a foreign company operating in the Philippines may be revoked if it is determined that the company has committed serious breaches of Philippine law or otherwise committed actions which would make it unfit to do business in the Philippines. In addition to a criminal penalty for a violation of its terms, some statutes enforce this administrative punishment. Next is the unfair trade practices. Unfair trade practices refers to the use of various deceptive, fraudulent, or unethical methods to obtain business. Unfair business practices include misrepresentation, false advertising, or representation of a good or service, tide selling, false free price or gift offers, deceptive pricing, and non-compliance with manufacturing standards. Such acts are considered unlawful by statute through the Consumer Protection Law, which opens up recourse for consumers by way of compensatory or punitive damages. An unfair trade practice is sometimes referred to as deceptive trade practices or unfair business practices. According to the Investopedia.com, unfair trade practice topic. Fighting unfair commercial practices leads to a high degree of consumer protection. It ensures that consumers are not fooled or subjected to aggressive ads and that any statements with emphasis in EU made by traders are transparent, factual, and well-founded, allowing consumers to make informed and meaningful choices. The goal of the directive is to ensure, encourage, and protect fair competition in the field of commercial practices. In the Philippines, the Ceres study 2008 found that due to data asymmetries, unfair trade practices, unfair standard contract terms, high search and switching costs, and imperfect decision-making processes, customers often do not take advantage of efficient competition. Moreover, while consumers are perceived to be the primary recipients of liberalized markets, this premise only applies where consumers are pricing and production sensitive and are thus able to look for the best price quality combination of offers. In conclusion, series observed that depending on the situation in which they have to make their choices, customer expectations tend to fluctuate. Individuals lack the capacity to construct constant and rational preferences because these asymmetries of knowledge and unequal trade practices affect them. Only a certain amount of information can be searched for and processed by customers. As a result, under particular conditions, individuals struggle to optimize their well-being and take shortcuts while making choices that may be inconsistent with supporting their own welfare. Finally, we can see that the scope and limits of enforcing corporate social responsibility codes have a wide degree of coverage both national and international law. These codes stand as the corporation's reference and/or instructions. In the debate and implementation of these codes, a large range of factors needs to be addressed. That's it for my report. Thank you very much and keep safe.